My Lord, for the record, Alex. My Lord, representation is as before. As earlier highlighted, I'll be dealing with issue number 3. And in particular, the illegal practice of bribery. My colleagues will later deal with the other practices and offenses. A lot would like to associate with the law on bribery as set out by my colleague for the petitioner. I would also like to upload my colleague Counsel Karle for the petitioner for the spirited submissions in support of this illegal practice. Unfortunately for court and in such election petitions, court is guided by the evidence of the witnesses and the petitioner. And my Lord, as I'm going to demonstrate hereafter, the petitioner and the witnesses miserably failed to discharge that verdict. My Lord, the law on bribery, as has been set out by my colleague under Section 80 of the Parliamentary Elections Act, and Section 81 in particular, 81C, that an election of a member of parliament can be set aside if it's proved that an illegal practice or any other offense under this act was committed by the candidate personally or with his knowledge and consent or approval. My Lord, that is the letter of the law. My Lord, 81. Formerly it was 60. 61. But under the new amended revised. My Lord, the 81C creates the illegal practice. Then 87 goes to bribery. Yes, my Lord. So I was coming, my Lord, from 81C that requires that the illegal practice should have been committed either by the candidate personally or with his knowledge and consent or approval. My Lord, I'm coming from this background because later on, as I will demonstrate, some of the authorities cited by counsel for the petitioner introduce other parameters that are outside the law. And as we demonstrated, some may be by curiam, but I'll read them, my Lord. My Lord, under 87, the offense of bribery itself is introduced. And the ingredients are highlighted there under. My Lord, what I will need to emphasize at this juncture is that the three ingredients under 87 must all be existent and must be proved. Must all be existent and they must be proved with cogent evidence. With cogent evidence. Before court can reach a finding that the illegal practice of bribery has been proved. And my Lord, that is the position as set out by Hearsay 1, which we have highlighted, 2001. Hearsay verses 7, which is the locus on this particular issue. My Lord, you cannot prove the alternative, that now since one ingredient has been proved, then there was bribery. You must bring cogent evidence on each of the ingredients, on the elements. The gift was given to a voter, it was by the candidate. If by the agent, then with his knowledge, consent, and approval. My Lord, I would like to move to the petition, paragraph 20. Paragraph 20 of the petition. The affidavit in support of the petition. My Lord, we have presented and demonstrated to court the effect of hearsay evidence. The effect of hearsay evidence, my Lord, has highlighted in the Hearsay case, the judgment of Justice Odoki, the judgment of Justice Odoki, my Lord, on what should be contained in an affidavit, of the kind, in an election petition. And court in arriving at this decision, my Lord, was guided by the law. Order 19 Rule 3 of the CPR provides that affidavits can only include facts that the deponent is able of his own knowledge to prove, except in interrogatory applications. Now, my Lord, an election petition like what we are dealing with is not an interrogatory application. My Lord, you posed the question when my colleague Bagenda was submitting that now what happens? The witness makes reference that I got this information from so and so, and those people come and they also give evidence. Is it still hearsay evidence? My Lord, the Supreme Court said yes, it is hearsay evidence, and the evidence that should be considered now is the evidence of the witness who has come, because what you did, you simply introduced them. But for your evidence to pass the admissibility test under section 59 of the Evidence Act, it must be the evidence you who saw, felt, perceived the set of facts that you're speaking about. Now, my Lord, the essence of this election petition, and I would like to make a juxtaposition as I take us to the petition itself. If the candidate says, I was told by my people that ABCD happened, the presumption is that when that witness comes to court, he will say what the candidate has said that he was told. Now, if a candidate says one set of facts and he claims that they were told by witness X, and witness X comes to court and does not make mention of what the principal or the candidate claims he had from that witness, then it makes the principal's evidence, the witness's evidence, hearsay, in as far as one, it does not disclose the source of knowledge, or the source which it imputes it to does not speak to the same. And my Lord, I'm going to demonstrate this by the petition before you. To demonstrate that all the allegations of bribery cannot stand. My Lord, in paragraph 20, the petitioner says, I state that before and on election day, the first respondents, agents, and campaigners, with his knowledge and consent or approval, committed the illegal practices of bribery. In particular, one, she says, I'm informed by Napkenya Margaret, which information I believe to be true. 2 says, I'm informed by Chamber Mwangu Nathan, which information I believe to be true. 3, I'm informed by Maumbe George William, which information I believe to be true. 4, I'm informed by Wanjala. Now she's telling court that she's informed by these people that with the first respondent's knowledge, consent, or approval, the following acts of bribery took place. Now, my Lord, the duty of court now is to go to the affidavits of these people. And my Lord, When you go to the affidavit, the affidavit of NALUKOOLA Margaret on page 1267 of the 1267 of the bundle of the petition, my lord, there is nowhere in the affidavit of NALUKOOLA, which is 3 pages. It goes from 1267 to 1269. There is nowhere in that affidavit where NALUKOOLA is stating that with the first respondent's knowledge, consent or approval, the alleged bribery took place. Because my lord, we are coming from the background and it was admitted to by counsel for the petitioner that there is nowhere on bribery where the first respondent is personally attributed to. So they are not saying that the first respondent is attributed to bribery anywhere. So it means it is agency. Now the principal, who is NAMBI, is saying and telling court that the first respondent, with the knowledge, consent and approval, she was told by these people. Now when these people, the witnesses, come to court in their affidavit evidence, NALUKOOLA does not state anywhere that the first respondent, with the first respondent's knowledge, approval and consent, this bribery alleged here took place. My lord, that is NALUKOOLA. When we go to the second, under 20.2, that is Chamber Nathan. My lord, Chamber Nathan is on 1273. My lord, equal. Now be saying that with the first respondent's knowledge, consent and approval, this witness does not mention the first respondent's consent, knowledge and approval. And it's a very key ingredient. Now Nambi is attributing this to the witness. The witness does not mention it anywhere in the affidavit. My lord, the same applies to Maumbe George William on 1276, and the same applies Maumbe George William on 1276 of the petition, and Wanjala Solomon on 1279. Now that leaves us and court with one question begging: from where did the petitioner get the information that with the first respondent's consent, knowledge, consent, and approval? Now, when the petitioner attempts to attribute that knowledge that I was told by these people, and these 4 witnesses on the illegal practice of bribery do not mention it anywhere, then it leaves the affirmance of Nambi in paragraph 20.1 to 4, hearsay evidence. And my lord, how do you treat hearsay evidence? My lord, like enough, the Supreme Court came out to serve petitions. Before that, we thought we would have the whole affidavit expand and the petition expand, because we know, and Nabi was here and testified in court that she was not there. I don't know what happened, I was not there, but the agents were there, they will say. The petition as it stands with the supporting affidavits, that is hearsay. Now the Supreme Court, in Dr. Kiza Wesley versus 7, and the judgment of Sekoko, which is the same as Odoki, they all agree the majority. He says, in my opinion, it would be improper in this petition to strike out the whole affidavits which are found to contain hearsay evidence in some parts, where the offending parts of the same affidavits can be severed from the rest of the affidavit without rendering the remaining parts meaningless. Without rendering the remaining parts meaningless. And my Lord, in a similar case where we had the petitioner relying on hearsay evidence, the Court of Appeal in authority that I've shared, that is used from Tembuli, it had already been shared to court, used from Tembuli. My Lord, in this case, briefly, the East Tembuli case, I refer to page 16, where the actual decision was, where they were still quoting the Supreme Court decision of Bessie. But my Lord, in this case, the land trial judge was faced with allegations that were set out in paragraphs 118, 119, and 120 of the appellant's affidavit, which constituted hearsay evidence. The paragraphs do not disclose the source of information. The land trial judge could have severed the offending paragraphs and proceeded with the other issues raised in the petition. He did not. He chose to look at the evidence as a whole from both the petitioner and the respondent before coming to the conclusion that he did. The Court of Appeal said hearsay evidence is severable. And my Lord, in this case following the Supreme Court decision, Court severed, expanded only those. And my Lord, is on this point that I'm making a prayer, this honorable court, as I've demonstrated above, that the paragraphs 20, 20.1 to 20.4 of the petition and the affidavit in support of the petition are hearsay evidence. And my Lord, the same should be expanded and severed. My Lord, the sum total of that is that if the petition itself no longer has evidence on bribery because it is not compliant with the law, then the witnesses cannot even come to testify on anything. In fact, it operates like a Russian poison. It collapses. The whole house collapses. When the pillar is cut, the house collapses, and the house of the petitioner on bribery should collapse at that point. But my Lord, in the alternative, and for argument's sake, because we have to respond to the allegations of bribery set out, my Lord, it's our submission, as Zaria highlighted, that the petitioner and her witnesses have not discharged the legal duty imposed upon them in proving the illegal practice of bribery. My Lord, I will go to the first instance in the format that our colleague, who was a petitioner, had approached the same. My Lord, that is the allegation under 20 11.1. Under 20.1, that is now Kenya Margaret. Now, my Lord, this evidence cannot be relied upon by this court for a number of reasons. My Lord, the information itself is contradictory. The evidence is contradictory. My Lord, as you will see later on in the cross-examination, before even we would subject this witness to cross-examination, the petition itself contradicted itself on this allegation. My Lord, I would like to refer court to paragraph 20.1. The petitioner says she was informed by Kenya Margaret that there was bribery by NALUKOOLA Rita to a one Chibuka Mary Diana on the 11th of March 2025. That's what the petitioner is telling court. Now, we go to NALUKOOLA herself. In the evidence of NALUKOOLA, my Lord, under paragraph 5, is NALUKOOLA also telling us the same? My Lord, in paragraph 5, NALUKOOLA is saying that I said that between 5 to 6 p.m. on the 8th of March 2025, NALUKOOLA bribed Chibuka Mary by giving out the same things that they. Now, we are left as court. Now, which of these two should court believe? On which date did this bribery, if any, take place? Is it the cogent? Is it the nature of evidence? That you want to be court to believe? My Lord, the contradiction does not end there on this person. Several to Subira Martin. My Lord, that affidavit of several to Subira Martin is on 1283. My Lord, this one allegedly is the one who printed. And when the witness, NALUKOOLA, was before court in cross-examination, she told court that she took these photos to Seburiba on the 9th and they were printed on the 9th. She told court that she took the photos herself on the 8th of March. But my Lord, when you look at the affidavit of Seburiba to Subira Martin, and in particular on 1286, where the photos are, the timestamp there is indicating that these photos were taken on the 11th of March. So my Lord, if it's true that these photos were taken on the 8th and they were printed on the 9th of March, then how come the timestamp on the photos indicates that they were taken on the 11th? Is it possible that they could have been printed before they were taken? Is this the kind of evidence that courts should rely on to prove bribery? And my Lord, the sum total of this, combined with the fact that even in cross-examination, when the witness was tasked to produce the camera that she used, after heated struggles from even her legal counsel not to let her go, she went home to pick her phone and came back 4 hours later with stories. So the whole chain of this evidence, its veracity, its reliability, is casting doubt and shadows. And as I will demonstrate, my Lord, as I conclude on all these issues, I will only submit at once on the case law. This is not the kind of evidence that could be relied on. And my Lord, most importantly, and this cuts through all the witnesses, my Lord, this witness confirmed to court that she is an agent and a supporter of NAMBI. My Lord, even when cross-examined heavily on who the MP of Kawempe North is, this witness was saying the MP of Kawempe North is NAMBI. My Lord, as I will later on show with the case law authorities that are available, these are not kind of witnesses that must be relied upon in the absence of independent verification and collaboration, because they are clearly partisan and their mission is to secure a win for their candidate. Even in court, the win that they failed to secure in the field, they come to court and the campaign continues. So as we thought they were in the dock giving evidence, for them they thought they were on a campaign platform. My Lord, I will go to the second incident. Hello, the second incident is Chamber Mwanguzi Nathan. And my Lord, before I leave the 20.1, the first respondent clearly in the affidavit in support of the answer to the petition denied this allegation. My Lord, there were affidavits of Nabakoza Rita, who was referred to here. And my Lord, Nabakoza Rita was very clear in her testimony. She also came to court to give evidence. She clearly even owned up the photos. And she even demonstrated to court that these are not the only photos. These were picked simply from a WhatsApp group. I have more photos. And she got to show court what she was doing at the time. She's a women counselor, and explained the circumstances of her actions. My Lord, there is even the affidavit of the person who printed, which was on record, and the Senagoria Dennis, which is on court record, with clear time stamps indicating the chain of this evidence. Counsel rose at some point and said, this person doesn't even know who printed. But the witness was here, said, we went one day here. I don't know the name of the person. We always don't know the names of the people we find in these public use places. But what is good is that the person who printed brought themselves before court through an affidavit. And the petitioner had the opportunity, if he had any misgivings, to call this witness for cross-examination. At least he did do that, he shied away. And the person who swore, having printed for NAB Kenya, developed a running stomach and he was reported sick when he was supposed to be coming for cross-examination after NAB Kenya. And up to now, we've not seen that person. So that witness went away. So Senapia was available for cross-examination, was on the list of cross-examination. After failing to break down NALUKOOLA, the petitioner feared to discover more truth. He said, Senabulia, no, that one I don't want. And my Lord, the effect of that is that that chain of evidence is very satisfactory to explain. But I would like to conclude by saying that, my Lord, the burden does not shift. The burden to prove rests on the petitioner throughout. I had counsel, my colleague say, you know, you've not denied well. Your facts of denial are very few. No! The Lord has not placed on me the obligation to prove denial. That is not what the law says. It is still your cross to carry to Golgotha. My Lord, on incident 2, under 20.2, my Lord, that is the one for chamber. My Lord, also would like to associate that this witness, first of all, makes allusion to Ben Ntale Mukasa and Sylvia Nachobe. My Lord, the first respondent swore an affidavit. He denied the allegations. Sylvia Nachobe and Ben Ntale Mukasa swore affidavits in which they also clearly denied these allegations. My Lord, the petitioner chose not to cross-examine these two people. Chamber Nathan was a self-confessed supporter of the petitioner, was a partisan witness by even his own admissions here. My Lord, although he talks about being bribed, it is also evidence of a self-confessed criminal. And my Lord, I'm going to demonstrate with case law authority. You cannot engage in criminality and then you come to court and you want to take benefit of the criminality. And court has been very emphatic on this. Section 87(2) makes the receiver of a bribe a criminal. It's an offense. And there are even penal sanctions that come with it. and court has guided you can't be part of a cohort of criminality, then you want to play the victim before court. My Lord, this witness, just like all the other three, were asked here in cross-examination whether they ever reported any of these instances of bribery to the police constables, to the presiding officers, or to the candidates. And my Lord, they said, no, they never. And my Lord, I heard my colleague saying, no, the Lord does not require you to report. And my Lord, that's wrong and misleading. And as I'm concluding, I'll demonstrate to this court with case law authority that it is important. There are provisions in the Electoral Commissions Act, there are provisions in the Parliamentary Elections Act that require you to report. Those provisions in the law are not redundant. They are not put there without purpose. And the essence of reporting when these things occur is to make sure that we have a clean election. So if you fail to report, there are two preponderances. One, that your election petition is an afterthought. these things never occurred. But you are simply a bitter loser. And how do you account for your loss? At least try to run to court, such that your voters don't ask you, what did you do with the few votes we gave you? Secondly, it could also be true that one is simply part of the chain of criminality, or is the criminal themselves. So my Lord, the affidavit of Chamber Nathan Mwamuzi, as I highlighted earlier, does not also indicate that this chamber and Sylvia Nachobe were agents of the first respondent. And my Lord, the law does not say you stop at agents. First of all, proving agency relationship is a cardinal requirement. But when you prove that, you do not rest and ask for water. The journey has just begun. Because when you prove that, then you must adduce evidence to prove that beyond being an agent, this person acted with the knowledge and consent or approval of the first respondent. And my Lord, I will make a generic submission on this. All the four instances, the witnesses that were brought to court, answered this question in the negative. And we were very deliberate, asking each of them in cross-examination, was this allegation bribery done with the knowledge, consent? And they said no. And I said we don't know. So if for you has come to court you don't know, are you shifting that obligation and legal burden to court or the respondent? And I will repeat, my Lord, that the burden does not shift. You come to court, carry your cross. So my Lord, incident 2 is not proved. And this is a lone witness. There are general allegations and submissions that were made by counsel that these are members of NUP. So by them being a member of NUP, then this one is their agent by implication. And my Lord, I'm going to address that because it is wrong both in law and in fact in light of the political atmosphere in which we operate, as I will show court. My Lord, the third instance under 20.3 is Maumbe George William. My Lord, I adopt my submissions on 1 and 2 on this third incident. And my Lord, I will invite court to note that this witness is a partisan witness, as he confessed in cross-examination the choice of his candidate. My Lord, this witness did not also report this to any authority, if indeed it happened. My Lord, this witness was asked, he said, you know, he gave me 5,000, he had a band of 5,000 he had received from the first respondent, NALUKOOLA. My Lord, that was not in his affidavit. Because in his affidavit even does not make reference to the first respondent having knowledge. But as part of his campaign platform, as Avalia said, they think when they are here it's a campaign platform, continue the campaign. He said, yes, that bundle he had gotten it from NALUKOOLA. And we were very inquisitive. Please tell court, where did NALUKOOLA hand over the bundle? he tried to do this and this. My lord, I'll invite you to go to the record when you retire. And finally, after being pressed for the third time, he said, no, I don't know where. NALUKOOLA gave him that money. He said, fine, you don't know that school. Then how much was it? He said, I don't know how much it is. So my lord, this I don't know witness, who doesn't know how much money was given, where, when, how much, cannot be relied upon by court to prove an allegation. And my lord, I want to associate with the petitioner's counsel that you do not need very many witnesses to prove. Even one witness is enough. But the court has cautioned that that one witness must be truthful, cogent, and must prove the allegation to the satisfaction of court on a balance of probabilities. It is true, we can even believe one witness, but that one witness must be free from all biases of being a partisan witness. He must be free from all biases of being an accomplice in the crime. He must be free from all encumbrances as indicated. And my lord, we submit that Maumbe doesn't qualify for such a witness. And this honorable court should not believe him at all in proof of the allegation of bribery. My lord, I'll go to the last one. Who is Wanjala Solomon? My lord, I will still admit my earlier submissions that Wanjala is a partisan witness. My lord, Wanjala is a self-confessed accomplice in the crime under section 87(2). My lord, Wanjala equally, when asked and tasked in cross-examination to prove if NALUKOOLA knew about this, consented about this, my lord, he broke down and said no. He broke down and said no. So my lord, his allegations was sufficiently answered to by the respondent. And my lord, as I will demonstrate, even under 20.2, where we had somebody alleged to have received Wamukubira. These other persons who received the alleged bribe did not. Chibuka, my lord, Chibuka Mary, Diana in 20.1 did not swear an affidavit to prove, collaborate the allegation. And my lord, even Wamukubira, under the affidavit of George Maumbe, did not swear an affidavit. And the same applies to Wanjala. So this makes them loners who cannot be easily believed. My lord, as I take leave of this matter, I would like to draw court's attention to the authority of a chain Saropendi. I think we have it. My Lord, that is volume 2, 676 in particular. Volume 2, page 676. My Lord, there in paragraph 20, court had this to say: that in election matters, partisan witnesses have a tendency to exaggerate claims about what might have happened during elections. My Lord, partisan witnesses placed in the context of what we are dealing with is Nakenya Margaret, Chemba Nathan, Maumbe George William, and Wanjala. That these ones have a tendency of exaggerating. In such situations, it is necessary, this is the Court of Appeal, to look for other evidence to confirm whether a particular witness is telling the truth. So, my Lord, as I take leave, I would like to say our colleague for the petitioner made some remarks about how this evidence is treated of illegal practices, and says there is no legal requirement to collaborate. My Lord, the authorities, right from the Supreme Court, the Kizabesi authority, which we retired, look at, where it comes to bribery, although it is proved on a balance of probabilities, but given its criminal nature, because bribery, unlike some other offenses, attracts with it penal sanctions. If it is proved here, court can even order police to begin from there. So court is required to consider more cogent evidence to its satisfaction, and in doing so, it goes slightly above the normal balance of probabilities in civil matters, in ordinary civil matters. However, it doesn't reach beyond reasonable doubt. And my Lord, the understanding is very clear, because only one incident of bribery, only one, is enough to annul an election.
So you are not changing the standard of proof?
My Lord, I'm not changing. I'm affirming what the Supreme Court has said, and I'm affirming what is here.
I thought you are compared with the petition, that the standard of proof is
On a balance of probabilities.
now you are saying it is a little bit high.
My Lord, it's not me saying, I'm confirming even the authority before you, that is our opinion, because that's what. Yes. In electoral offenses, and my Lord, we are flowing from Justice Odoch, the Chief Justice, that election petitions are sui generis. They are sui generis. Yes, they are civil matters, but one of a kind. Because we shouldn't lose track of that. And in all the authorities, even those that have been given, it's a requirement. Because one incident alone, even 500 shillings can annul an election. Even 500 in numbers, one, it is immaterial of the amount. Even one person bribed is successfully proven. So because of that legal burden, the standard is not as usual. The balance of probabilities is not a balance of probabilities ordinarily. In essence, my Lord, and my Lord, that is on 6-7. And my Lord, if I will even just go there, apart from the evidence of Agnes Ocho, the Court of Appeal was saying there is no other piece of evidence to corroborate Agnes Ocho's evidence. These allegations by Agnes required some other evidence from an independent source to confirm the truthfulness or falsity of her allegation. Just like all of these who have come here, Agnes said, I was given 2,000 to vote, to leave one person and vote the other. And she said, no, I was supporting this one whom they told me to leave. She was cross-examined and so many things came out. The Court of Appeal said, no, you can't rely on that one person. You need some other evidence. So, my Lord, the requirement for collaboration is very imminent. And I will invite my Lord Court to go through that authority at those pages, and we shall be able to discern that there is need for collaboration. My Lord, there is something else that was highlighted by my colleague, which I think we need to clear. The requirement to report. The requirement to report to the Electoral Commission, to report my Lord, under Section 65 of the Parliamentary Elections Act, it makes it a requirement for a candidate or any voter present at a polling station to raise report and of any incident that happened, my Lord, a candidate and a voter. Now we had candidates, agents, all these witnesses who came, they said they're agents. Others said, for me, I'm a voter, I'm not an agent, fine. But then 65 tells you that for anything that happens at the polling station, the offenses, the what, report to the presiding officer or to the constable, police constable. And my Lord, this was also traversed in the chain case before you on page 682. This was the petitioner's authority submitted. My Lord, I will not submit a different one such that I can use the real one for the petitioner to drive this point home. My Lord, on paragraph 35, on the judgment of Justice Remy Kasule, as it then was, my Lord, in this instance of the son of the painting, these candidates talked about who were bribed in the morning, this happened, none of them reported. And the Court of Appeal says, under 35, about this Agnes Ocho, for example, she gave no plausible explanation for her deplorable conduct. If at all this was the truth, she did not also report this alleged bribe to any officials, including the elections officials or the police, who are readily available, which too was very strange. My Lord, the instance of reporting, at least it is the first instance. When they do nothing, the Act provides for the remedy. How do you do? If you report and nothing is done, what do you do? It's in the Parliamentary Elections Act. And the reason why it is important to report is that when you come for an election petition like this, we shall not look at you as a bad loser. You are in an afterthought, you are bitter. And my Lord, that is the Court of Appeal. And I will supply, my Lord, this honorable court with another thing. My Lord, in the case of Nakato Mary Annette versus Babili Veronica Kadogo, the Court of Appeal, 2016, Nakato Mary Annette versus Babili Veronica Kadogo and another, EPA number 89 of 2016. to the effect that at every polling station, my Lord, that's page 22 of that judgment, which I'm going to supply to court immediately. At every polling station, there is a police officer, constable, charged with the duty of keeping law and order. The appellant and her agents neither reported to the police about such illegal acts, and they did not also report to the Electoral Commission. The allegations coming up later can only be considered as an afterthought, not supported by evidence. We find on our reviewing all the evidence that the land trial judge was correct when he held that the allegations were not proved to the satisfaction of court. The judge's requiring corroboration of such evidence was done as an endeavor on his part to determine whether he could place any credibility on this evidence. He rightly evaluated all the evidence and gave the reasons for rejecting the same. And my Lord, the Court of Appeal found no fault on the trial judge in the way he went about evaluating such kind of evidence. My Lord, we invite you to treat this evidence the way it was treated in this case, and the Court of Appeal will not find you at fault even if they reject the same, because it does not meet the legal threshold for reliance. And my Lord, as I also get this authority to court, my colleague talked about a new concept. And my Lord, that new concept is imputed agency. Imputed agency or political agency. My Lord, the law is clear on the agent's embassy. Non-election. My Lord, there are two agents. The polling agent my last under 51. Under section 51. Now, my Lord, the agents there are the polling agent and the representative. Because when you are nominated, there is somebody called the official agent who represents the candidates, because the candidate is expected to be running up and down. There are times when the EC has something to follow up. They must have a contact of somebody. Then, my Lord, you have the polling agents who represent the candidates at the polling station. Now, my Lord, section 87 introduces the concept that the candidate must have personally done so, or his agent. And these agents will include the polling agent, the official agent, and case law has extended this to agents who, by conduct of the party, of the candidate themselves, are represented to the people that this is my agent. And that scenario arose in the Odo Tayewa case, which you have cited. In that case, there was somebody who would move with the candidate everywhere. During campaigns, when the candidate would be called as a guest of honor, this person went. Said, I'm honorable. When they call, and these things happen even on barriers. This is when you go to the village. Hopefully, I'm not giving evidence from the back. But they call a member of parliament, say, honorable, but you come and say something, then you see a waswa coming. Then he starts speaking on behalf of the MP, like he's the MP, even gives Maugo and other things. Now, the law has now said that no, when one goes into that and the principal leaves it continue for some time, and the whole public gets to know that where you reside in Uganda, you have seen Honorable X, then in those circumstances, you may not easily deny agent's relationship, even if that agent has not been strictly the one in the law envisaged under the Electoral Commission Act and the PIA, then this one may also be your agent. So, my Lord, the petitioner had the obligation to demonstrate that for these alleged persons, which they did not do. And for purposes of saying that one is a member of the political party, so that automatically makes them an agent, is misleading. Council gave submission, making allegations on the affidavit of Lubongoya Lewis. My Lord, the affidavit of Lubongoya Lewis is on the first respondent's trial bundle, and my Lord, we shall invite this honorable court to peruse the same when you retire. There is nowhere in the affidavit of Lubongoya where he says that they had these officials campaigning everywhere. He gives his role as ESG and his role in this campaign. Now, the council says these Ntale, Ben, and Nabakoza are officials of the party. My Lord, is also misleading. And court handled the same in the case of Ntwantua Bagara versus Nabakoza. My Lord, I will present that authority to you. Because there the High Court had said, no, because these are all members of NUP, then they are all liable. The Court of Appeal said, no, belong to the same political party does not make one an agent. My Lord, is the authority of Bagara Ntwantua versus Nabakoza Judith Narule, EPA number 68 of 2021. My Lord, the Court of Appeal here said, no, the petitioner must create a nexus and establish an agent relationship. It's not enough to say that these are party members. And even when you do so, you must go ahead and demonstrate that they acted with the consent. My Lord, that's on pages 31, 32 of the authority of Barbara Joyce, which are supplied to court. So, my Lord, it's also not true on the agency, on the political agents. My Lord, Council cited a case. Council cited a case. Here's my volume 3. The Indian case of Gopal. Just be sure, I wanted to note the page. I wanted to highlight the page of the Gopal case. My Lord, it is 1179. But in particular, on 1181, on 1181, my Lord, first of all, we would like to say that that case is not applicable and distinguishable, because what Council was citing is a provision under the People's Representation Act of 1951, Laws of India. And my Lord, I will refer court to go to 1181, from 1181. That is the context. Now, those requirements of extending agents to political parties and others is in the law. Now, the law governing the particular election we are dealing with is the Parliamentary Elections Act. And under Section 80 and then 87, it is the electoral mandatory that you must establish knowledge, consent, approval of the candidate. It's not implied. So the authority cited of Bhopal, India, was following that act, and that act is not applicable here because we have a specific law guiding this election. And to invite courts to ignore the law here and import another law would be to invite it to act by curiam, which, as we have demonstrated to court, the same is not permissible. But my Lord, if I would, for purposes of counsel read out the most relevant part of his submission. And even if that case was applicable, which we say is not, because it's based on another law, even that law, if my Lord, when you retire, you go to 1182, to page 1182, it clearly shows that because it is common knowledge that in elections many strangers start taking interest who have directly no concern with the candidates or the election agents and have never been asked to do anything in the election. My Lord, in one of the Ugandan authorities, they call them overzealous voters. One makes themselves an agent of you and they start doing things without your knowledge or what. It is incumbent that you must prove consent of the candidate, even under this act, which is not applicable, but we read it beyond where the petitioner and the lawyer had ended, and we invite God to also look at the same. So, my Lord, we, in brief, say that it's not true that we can have political agency. The party must prove that indeed such a relationship exists. With that, my Lord, it's our submission that the issue on bribery be answered in the negative. And my Lord, for the record, just a reminder, I've spent 80% of my time submitting on a non-existent petition on bribery. Because as I highly highlighted, these grounds cannot stand on the ground of hearsay. But if court is not pleased with those submissions and the laws, and it goes to assess the same, we also say they do not meet the threshold. Most of my time.
Okay, is there anything else?
No. Just to supplement the case of the political agency. Yes. In the Supreme Court, in election petition number 1 of 2016, Amala Mbalas versus His Excellency Joel Kaguta Museveni, on page 215 to 216, where the actions of the RDCs of intimidation were being attributed to the first respondent, His Excellency. This is what the Supreme Court said. The petitioner's attempt to attribute the acts of these individuals to the first respondent is not sustainable because there is no way a candidate could control some overzealous supporters steering posters of other candidates or supporters provoking fights and engaging in a fight with supporters of another candidate. In this regard, we found no evidence to associate the first respondent personally with his consent or with the alleged intimidation and disruptions of rallies. So, court removed the concept of political agency and hence vicarious liability of the same crime offenses. This This was already submitted by the second respondent and the extract is highlighted. My Lord, we go to the second illegal practice or offense of obstruction of progress. This is provided for under Section 90 of the Parliamentary Act, and the petitioner alleges two incidents, one happening at Kalanda's compound, N to N police station, and she says she was informed by the said BAMBI, Sherina, Hassan, and Deborah that this happened on the following day. The other incident is the Kalanda's home, polling station O to Z, and her co-agent Kabumba and her were obstructed. My Lord, these were political agents, polling agents that are giving evidence, and they are also partisan witnesses. We are associated in the same submissions that their evidence needs to be corroborated. But my Lord, there are material contradictions and inconsistencies in their evidence. In her affidavit at page 15 of her petition, she cites number of persons that carried out the same obstructions. The Kenya Body, paragraph 15 of her affidavit. I believe it's paragraph of the petition, paragraph 15. I'm going to confirm the paragraph. It's paragraph 9.2 of her petition. It is paragraph 18 at page 15 of our petition. Sorry, my Lord. However, neither Validi in their affidavits mention Fred, Chibira Fred, as being a participant. They mention a one participant who is female, almost obvious. But none of her witnesses. This is in her affidavit, in paragraph 18. When you go to the affidavits of the witnesses, they mention no female participant. Yet in her affidavit, she has a female participant by the name of Auma Scovia. Auma Scovia is not mentioned anywhere. Nansanga Deborah, who was meant to corroborate the evidence of Baride Sherina, mentions a different Sherina. She mentions that the person whom she saw at that polling station was...
This Auma Scovia.
Yes.
Fred. With your point, I think it is.
The points are that there are these evidence presented by court has material inconsistencies.
Here, they are mentioned in paragraph 3. Then,
Paragraph paragraph 18.
18.
Yes.
Then at some point you said
Both witnesses, their affidavits, both witnesses, Valide Sherina and the Nasanga Deborah, don't mention of a female participant. For her, she says there was Auma Scopia in paragraph 18 of her affidavit. Yet the witnesses all mention only male persons that are alleged to have committed the crime. Then Nasanga Nasanga, in her own affidavit evidence, that is paragraph 33 to 6 at page 1260, she says she arrived at Kalanda compound polling station AN to N and alleged saw her friend, Naukena Sherina, being beaten. She does not identify the said polling agent or the petition, who is Valide Sherina. So these are two different people. Yet she was made to give evidence in corroboration of Valide Sherina. They said Naukena Sherina never gave any evidence of her being beaten. Naukena Sherina, Valide Sherina says that she was beaten, but no medical reports. She said 3 men came being led by Chivirango, beat her. She doesn't present any medical report of the said allegation, which body part she was indeed to confirm whether she was indeed beaten. And she didn't report anyone. My Lord, what is strange with the Valide Sherina, she said after all that, voting continued. If she was indeed obstructed, voting continued, she was rescued. Then, at the end of the counting of votes, that's when she requested the presiding officer to make that in his report. If she was indeed obstructed, she wouldn't have even carried out her work, because obstruction literally means being stopped or being prevented from what you are doing. She continued carrying her work as a polling agent until the end. She said she reported a case of threatening violence. No investigative report has been furnished to know where it states it has reached nothing. My Lord, with these inconsistencies, contradictions, and speculative assertions, this evidence is indeed unreliable and unpersuasive. I want to associate my submission with my line colleague. The averments made by the petitioner that this act was done with the knowledge, consent, and approval by the first respondent, as averred by the petitioner herself in paragraph 18. The same content is not there. Therefore, the said two affidavits, and she mentioned her informants about the same as being Valide Sherina, Chemakai, Eli, and Nasanga, Deborah. The said affidavits are contradictory and do not corroborate. Therefore, this evidence is also here, my Lord. And should be disregarded. My Lord, the presidential petitions of Amal and Babas and the Act itself says these offenses are personal, any person. When you read section 90, it deals with any person. A person who at an election, even the one for obstruction of polling agents, it says a person who obstructs polling agents. Going back to the referring to the Supreme Court decisions in the last paragraph with regards to the electoral offenses. The Supreme Court said the offenses, lastly, the acts alleged of intimidation and interference with electioneering activities of other persons were committed by individuals. And Section 26 of the P provides for a penalty, which are 90 and the 102 against the person who committed the specific offenses specified in the provision. That is page 215. Therefore, these personal offenses, it was wrong to attribute them to the first responders. What the petitioner would have done is commence criminal proceedings against the same persons themselves. The Kidirangos, the Honorable Barimwezos, the Sam Cassidy, and Auma Skobia as alleged. My Lord, the other offense is obstruction of electoral officials as averred by the petitioner in paragraph 3.1, 9.31 of page 6 of our petition, and paragraph 19, 1 and 2. 19.1 of her petition, which is page 15 of our affidavit. She alleges that electoral officials were obstructed. They say electoral officials are not named. They say electoral officials are not named. That is the affidavit of Kimakai Chikamai Eli. My affidavit is on 1239 of the petition. What is strange with Kemai's affidavit, she says, although she says the other paragraph says that the presiding officer reported these activities to police. But it is impossible for the presiding officer to leave any polling station during the conducting of polling to report the case. He has to be present until counting. And she does not have stated in her affidavit whether polling was stopped during the time the presiding officer was reporting the alleged offense. The second respondents denied this incident in their affidavits. They say there was no disruption of their polling officers or their employees, that they conducted the election as required. the victims themselves that they are saying were obstructed are not complaining. So we would wonder where the petitioner got the local standard to make such an allegation. If the victims themselves are saying we conducted the election without any disruption. When you read the further evaluation of her affidavit, she says that it was Hilderman, Hearsay at Gazo, Angola. The time, she does not specify the time, but from the reading, it happened between 10 a.m. to 11 p.m. That is under paragraph 5, 4 and 5. She puts Hilderman at Gazo, Angola polling station, Nak to Namaz. Yet, her co-witness or witness of this puts Senator Lawrence under paragraph 12.2, 19.2, puts the same Hilderman. Masuti's affidavit is on page 1262. At the same time, when Hilderman is another polling station, that is Namaz, he puts Senator Lawrence Masuti, puts Hilderman with Dennis Rumomboya under paragraph 7 on a different polling station, which is Gazo Angola SP to Z. You really wonder how could Hilderman be in the same place at the same time, two different polling stations at the same time. These glaring contradictions indeed cast doubts that the same offense was indeed committed by the alleged persons. There was no proof that Hilderman was an agent, and these acts were done with the knowledge, consent, and approval of the first respondent. Therefore, my Lord, we pray that you find that the petitioner adduced insufficient evidence to prove the same, and the said direct offense have not been proved. My Lord, we go to the last electoral offense. The petitioner alleges there were 4 incidents of campaigning on polling day, contrary to section 63(1), 2 paragraph A and B, section 100, subsection 1, paragraph A, D, subsection 2 and 3 of the Parliamentary Elections Act Cap 177. My Lord, the reading of this act does not bar campaigning on election day. It only gives a radius. You can do it, but on a radius between 100 or 200 meters from the polling station. Campaign. These provisions prohibit campaigning beyond midnight on the eve of polling day. Then to canvass, this is what it reads. Without derogation from any other provision of this act or any enactment, a person shall not be within 100 meters of a polling station, on a polling station, or on any polling canvas for votes. within 100 meters. That is what it's saying. This is the law. So it does not stop someone from coming, it just gives a radius. That is the law, section 101. But there is no, but the burden squarely falls on the petitioner to prove that this happened. The petitioner alleges that some of the affidavits alleging these allegations were never rebutted. Section 100. Yeah. Some of the petitioner in her submissions was saying that some of the affidavits were never rebutted about these allegations. He's saying the supplementary affidavit of Mulindwa Mike, and was saying that the reply was a mere denial. My Lord, the cardinal evidence rule is that he who alleges must prove. So the petitioner, this is it espousing Hosea Solomon 11 verses Okul Joseph Andrew and another. Election petition number 2, High Court Sorority election petition number 2 of 2021, where Honorable Justice Musa Sekan says that the burden, that is on page 23 and 24, says that the evidential burden of proof does not shift to prove the existence of a particular act to the respondent. The petitioner's evidence cannot be taken as gospel truth merely because the first respondent never made a specific answer or response to his wild and baseless allegations. So even if the respondent does not rebut, or barely denies the said allegation, the evidential burden still relies on the petition. Refer to the Supreme Court of Zambia's election petition number 1 of 2006, which was between Anderson Kalemba Makosa and 2 others versus Patrick Manawasa and 2 others, where the Supreme Court of Zambia held. It follows that for the petitioners to succeed in the present petition, it is not enough to say that the respondents have failed to provide a defense or to call witnesses, but the evidence accused establishes issues raised to at a fairly high degree of convincing clarity, in that the proven defects and electoral flaws were such that the majority of voters prevented from electing the candidate whom they preferred. Simply, what the common law position is that the evidence of the petitioner should not be taken as gospel truth. They still have the burden to prove that these electoral offences were committed, despite the mere denial on and rebuttal. when we evaluate the evidence of the first incident, that is at Imbogo Primary School playground, cut KAT to MJA polling station. The petitioner relies on the affidavit of her polling agent, who is called Gordon Salim Saleh, who claims the incident happened around 3 p.m., no specific time. During all submissions, the petitioner submitted that this would have occurred around 4 p.m. That the first respondent came to the polling station and chanted "People Power, Our Power" and urged the voters to vote for him by saying "Inze NALUKOOLA." With respect, the testimony is really inconsistent. First, there is no clarity about the time of the alleged incident. No time is given. During the affidavit evidence, they are saying 3 p.m. During the oral submission, 4 p.m. They do not specify in their affidavit the distance. The law talks about the distance. If indeed the distance is not there, that is established in violation within section 100, the distance is not there. There is no, the other point is, apart from the evidence of Gordon Salim Saleh, who is a partisan witness, furthermore, there are no photographic evidence, video, or independent corroboration presented, despite the prevalence of smartphones. Actually, the question you would ask, who does not have a smartphone? Almost everyone has. The only evidence they are relying on is a partisan polling agent whose testimony remains uncorroborated and inconsistent. Yes. Among all those people that were polling, it does not specify the number of the people. The first respondent was converting for votes. In the answer, the first respondent denied under paragraph 10 of his answer, although he admitted being within the constituency. That does not amount to canvassing for votes or campaigning within that area. His presence is not proof of valuation because he's allowed to move. Council cross-examined him that whether he's allowed to move after electing, he said, "I'm allowed." So in the absence of clear evidence, there is no evidence to meet the required standard. There is no clear evidence to corroborate or prove that indeed the first respondent uttered those words or canvassed for votes as alleged on that polling day. My Lord, we go to the second incident, which is the Kazo Angola KAL to KZ polling station. The petitioner relies on the evidence of PW5, which is Muamanya Saliva and Kalenzi Medi, who claimed the first respondent told voters, Amani Gabantu, the Mugaria Mungu, don't betray people power. Those are translated. Again, the crucial elements, if we are to believe that this happens, the distance is not mentioned. The distance is missing because the ingredients of the offense is canvassing for votes outside the 100 and 200 meters. Is missing. Contrary to section 63 or 100 of the PA as arranged. They do not mention the time when this happened. When you evaluate these two affidavits, one says the first respondent at that polling station caused commotion. The other said his presence caused commotion and disorganized the election. So we don't know which is true, according to the evidential burden of proof of establishing this offense. And my Lord, saying Amani Gavan and Mugalia does not literally mean asking for votes. Like vote for me, no. They don't bring proof that he said, vote for me. Most political expressions are devoid of this is just a mere political statement, devoid of any solicitation of votes as arranged. And this is not true because of the inconsistencies between the petitioner's affidavits, the witness affidavits. It's not true. The third instance, end to end. The petitioner alleges that an LC1 supporter of the first respondent called Zilige Musa and now Koza Rinja campaigned for him by holding his posters and soliciting for votes. This is by Kato Ronald. He says that he was a polling agent at that polling station, and after Zilige had voted, he held a poster and urged voters to vote for the first respondent. And likewise, Nansamba Jane, who claims she was asked by Musa and Rita to vote for NALUKOOLA, for the first respondent. There is no evidence to support, my Lord, there is no independent evidence to support this allegation. The alleged campaigners were not shown to be agents of the first respondent in any legal or formal sense. As my senior colleague has said, being mere members of the same party does not mean one is an agent of the other. To put it in another way, political affiliation does not impute agency, as by the Supreme Court decision. There is no concrete evidence that Zilige and Rita acted in the direction or approval of the first respondent. This was confirmed in cross-examination of PW4. He said she has no proof whether it was done. When you look at PW4, about the time when this happened, there is contradictory. She says in her affidavit she began her journey from her home to cast her vote at 10 a.m. Then during cross-examination, she said that this incident happened at 10 a.m. This inconsistency undermines her credibility. Because it can't be that she was moving from home to the polling station and then saw the first respondent, saw the GBD. In her affidavit evidence, she says she was asked at the gate by both Rita and Musa to vote for the first respondent. In cross-examination, she said this happened after she had voted. And she was asked, Otulonze, did you vote for us? That's what she said in the Ghana. So those inconsistencies in her evidence or testimony undermines her credibility. My Lord, just to sum it up, these electoral offences having a criminal nature, as my senior colleague has submitted, it is not to be proved on a mere balance of probabilities, but a bit higher. The evidence presented by the petitioner is solely on partisan witnesses whose testimony, as we have demonstrated, is inconsistent and should not be relied upon to find that the petitioner committed these offenses. With that, my Lord, we submit being answered in the negative. My own colleague, Rennie, is going to show you the cases that offend us.
Okay, before that,
on the eve, to the section 63, at midnight, section 53 of the
now that one, first change. You first.
yes.
Yes. So the scope of the eve. So the eve. This was the body.
The day before.
The day before. So now vis-a-vis the 100 meters radius. You explain that information.
No, it is the law what is saying.
No, I mean the
That is under section 100.
yes.
Yes. Yes. Okay. What with section 53? It means that you cannot campaign on polling day. I will draw the submissions. Because it's section 100 is subject to the provisions of this act. When you read it, without derogation from any other provision of this act or any other enacted, a person shall not be within 100 meters of any polling station on polling day. But no, as I submitted, no evidence was presented to prove the said allegation or report that you campaigned.
Yes, my Lord. I had mentioned the case of that is Admissibility.
Yes.
Presidential election petition number 1 of 2006. I wish to put it on record because we may not have
No, it's okay.
But my Lord, I am requesting, since it's a little voluminous, my Lord, I am requesting that I mark the areas of interest. I have highlighted, my Lord, so that I can bring them tomorrow. My Lord, also, you had asked me to highlight some of the cases that we thought would be distinguished by these decisions. My Lord, some of them include the case on parameters of ages. That should be Mayanda Banat. Then, my Lord, there is also another case on political agents. I think that is the Amkama Keija. Political agents. My Lord, those all are settled by both decisions. The one of 2001 and the one of 2006. And the one of 2006 buttresses the principle that I had already highlighted of the numbers. The numbers, decision of fact. In fact, it gives about 4 scenarios. And that is the one that mentions, can we juxtapose 150 against 10 million? Yes, there is disenfranchisement, but what is the effect of that disenfranchisement? I will highlight and I will bring them.
So, my Lord, we had highlighted that initially that we'll be covering these areas, issue by issue, and we believe we have ostensibly discharged that duty. My Lord, the sum total of the first respondent's submissions is that the petitioner is not entitled to any of the reliefs sought by this petition. My Lord, in line with the precedents before court, guided by stare decisis, this petition should be dismissed with costs. We so pray, my Lord, and we thank you for accommodating us.
May it please your Lordship? Yes, my Lord, and we are given tomorrow morning to rejoin, and we will do so, your Lordship, within a very short time or more. We oblige, my Lord.